So here's the motion to dismiss for Hannah C. Dugan, and I'm just going to read it. So this is the United States District Court, Eastern District of Wisconsin, the United States of America, Plaintiff v. Hannah C. Dugan, Defendant. Case number 25CR00089, Defendant's motion to dismiss. Honorable Hannah C. Dugan moves for an order dismissing the indictment. This is no ordinary criminal case, and Dugan is no ordinary criminal defendant. Dugan is a Milwaukee County Circuit Court judge. She was arrested and indicted for actions allegedly taken in the immediate vicinity of her courtroom involving a person appearing before her as a party. The government's prosecution of Judge Dugan is virtually unprecedented and entirely unconstitutional. It violates the 10th Amendment and fundamental principles of federalism and comity reflected in that amendment and in the very structure of the United States Constitution. The problems with this prosecution are legion. But most immediately, the government cannot prosecute Judge Dugan because she is entitled to judicial immunity for her official acts. Immunity is not a defense to the prosecution to be determined later by a jury or court. It is an absolute bar to the prosecution at the onset. See Trump v. United States, 603 U.S. 593 630 2024. This was filed the 14th, so yesterday. And this is in front of the judge, L.A. Judge Dugan reserves her right to seek other relief, including by other motions before and at trial. But the immunity and federalism issues must be resolved swiftly because the government has no basis in law to prosecute her. The prosecution against her is barred. The court should dismiss the indictment. Rule 12b, Federal Rules for Criminal Procedure, allows the court to grant the relief Judge Dugan seeks. In support of this motion, Judge Dugan shows: Number 1, the indictment charges Judge Dugan with concealing a person from arrest and obstruction for actions she took in and near her courtroom. The alleged conduct ranges from directing people's movement in and around the courtroom to advising a party that he could appear remotely for his next hearing, ECF 6 at 1-2. The complaint alleges a more cohesive story. In pertinent part, it alleges the following. On Good Friday, April 18, 2025, Judge Dugan was presiding over her misdemeanor docket in the Milwaukee County Courthouse, ECF 1, paragraph 15. Among the many defendants with hearings that day was Eduardo Flores Ruiz, id. paragraph 22. IBID, so go back to EFC 1. These are documents, EFC 1, 2, 3, 4, 5, 6. Federal agents arrived at the Milwaukee County Courthouse to execute an administrative arrest warrant for Flores Ruiz, id. Paragraph 8, a deputy in Judge Dugan's courtroom claimed that Judge Dugan directed Flores Ruiz to leave her courtroom through a jury door. Flores Ruiz emerged from a doorway into the same public hallway a few feet from Judge Dugan's courthouse doors. Federal law enforcement saw him, followed him to the elevator, continued to follow Flores Ruiz out of the courthouse, and then arrested him after a foot chase. Even if, contrary to what the trial evidence would show, Judge Dugan took the actions the complaint alleges, these plainly were judicial acts for which she has absolute immunity from criminal prosecution. Judges are empowered to maintain control over their courtroom specifically and the courthouse generally. Stevens v. Osuna, 11th Circuit, 2017. The issuance of an order removing persons from the courthouse in the interest of maintaining such control is an ordinary function performed by judges. Judge Dugan's subjective motivations are irrelevant to immunity. Judges are entitled to absolute immunity for their judicial acts without regard to the motive with which those acts are allegedly performed. According to Trump v. U.S. In dividing official from unofficial conduct, courts may not inquire into the president's motives. Since at least the early 17th century in England, and carried on through common law in the United States, judges of record have been entitled to absolute immunity for official acts, with a few exceptions not applicable here. Floyd and Barker, Star Chamber, 1607, Bradley v. Fisher, 1871, Pearson v. Ray, 1967. Judge Dugan, therefore, has both immunity from conviction and immunity from prosecution. The essence of immunity is its possessor's entitlement not to have an answer for her conduct in court. Trump, quoting Mitchell v. Forsyth, Mitchell, the entitlement is an immunity from suit rather than a mere defense to liability, and like an absolute immunity, if it is effectively lost if a case is erroneously permitted to go to trial. Congress did not abrogate this common law immunity in 18 U.S.C. section 1071 in 1505 as it did in 18 U.S.C. section 242. Compare Pearson. 42 U.S. section 1983 did not abrogate civil judicial immunity. To Imbler v. Pochtman, 1976, 18 U.S.C. section 242 allows the criminal prosecution of judges for civil rights violations. Congress enacted 18 U.S.C. section 242 under section 5 of the 14th Amendment with an express focus on the unconstitutional behavior of state actors, including judges, but 18 U.S.C. section 1071 and 1505 are generic criminal statutes enacted pursuant to Congress's Article 1 powers and reflected no congressional intent to abrogate a bedrock immunity available to state judicial officials. It is doubtful that Congress's Article 1 powers would extend to criminalizing the actions of state court judges in their courtrooms. Criminalizing the official acts of a state court judge controlling her courtroom would implicate all the concerns that motivated the 10th Amendment, and nothing in this indictment alleges any violation of a person's constitutional rights in ways that implicate the unique concerns of the Reconstruction Amendments. But the court need not decide whether Congress could have abrogated judicial immunity in 18 U.S. section 1071 and 1505 because Congress did not do so. Neither should be construed to criminalize an official act of a state court judge, and the indictment does not allege that they do. The problems with this indictment run deeper. Immunities aside, the indictment runs afoul of the 10th Amendment and constitutional principles of federalism. Federal power is limited to specific enumerated areas in the Constitution. All other powers are reserved to the states, respectively, or to the people. U.S. Constitution Amendment 10, that includes the general police power. The states retain it. The federal government does not have it. Unsurprisingly, then, the American judicial system empirically is almost entirely the realm of the states. Federal civil jurisdiction is limited. U.S. Constitution Article 3. Federal criminal jurisdiction is limited. CEG U.S. v. Lopez, 1995. That's why over 99.4% of criminal cases filed in this country are in state courts. The government's prosecution here reaches directly into a state courthouse, disrupting active proceedings and interferes with the official duties of an elected judge. A state defines itself as a sovereign through the structure of its government and the character of those who exercise government authority. McDonald v. U.S., 2016, quoting Gregory v. Ashcroft, 1991, Judge Dugan was elected by the people of Milwaukee County to adjudicate their disputes and administer the laws of Wisconsin. Wisconsin Constitution, Article 7, Section 2 and 7, the federal government violated Wisconsin's sovereignty on April 18th when it disrupted Judge Dugan's courtroom, and it is violating Wisconsin's sovereignty now with this prosecution. The court should end the violation of Wisconsin's sovereignty and dismiss the indictment. As a practical matter, counsel for Judge Dugan stand ready to file briefs and to participate in an evidentiary hearing if either or both will aid the court, but they stand on the observation that any further proceedings in this case other than immediate dismissal are barred by official acts immunity and judicial immunity. Regardless, in the event this prosecution moves forward, Judge Dugan reserves her right to supplement this motion with briefing and other filings submitted within 20 days of arraignment as provided in Criminal Local Rule 12B1, dated at Madison, Wisconsin, May 14, 2025. Respectfully submitted, Honorable Hannah C. Dugan, defendant, signed by R. Rick Resch, and then you have John H. Bradley, Dean A. Strange, Rick Resch, William E. Grau. And I guess those are the lawyers' numbers right there. And then there's some emails. Here's another sign. Stephen M. Biss Cupic. I guess this is the firm, Strange Bradley LLC, and then this is Stephen Biss Cupic by himself, and then you have another Jason D. Luckzak, and that's with Nicole M. Maznica, Gimbel, Riley, Gurin, and Brown. So you have a couple. You have 1, 2, 3, 4, 5, 6, 7 lawyers. 7 lawyers signed this thing. So that's actually a fascinating document for a bunch of reasons. I'm just going to make a few comments. So it's interesting that they're saying, well, actually Trump administration can't arrest a judge because of the Trump decision of 2024. So that's big time ironic, is it not? And saying immunity is not a defense to the prosecution, then saying see Trump v. U.S. I wonder what they quoted there, because the Trump decision said that the president has immunity as long as in his purview of official acts, right? And actually there's a whole bunch to the Trump decision, but immunity as a concept, I cannot stand immunity as a concept. The only 2 places in the Constitution where immunity is even mentioned is in the context of the rights of the citizens. There's a privileges and immunities clause, and then there's a privileges or immunities clause. One's in the body of the Constitution, and the other one is part of the 14th Amendment, Section 1. So when it comes to immunity, immunity is only for you and me, we the people. The citizens get immunity when it comes to our rights. So when these public officials keep on trying to say that they're immune, there is, case law, and then that's not common law. Don't even get me started on fucking common law. Don't even get me started on common law. Common law is bullshit. The old ancient English common law, we're supposed to not only read all of America's laws, but we're supposed to read King Henry VIII, his laws. Give me a fucking break. Now, this is a motion to dismiss, and it's worded very well, and I wonder if they're actually going to dismiss it because of, this motion to dismiss. It's worded very well, signed by 7 lawyers, right? This does, kind of scare the shit out of everybody. Because if the Trump administration can arrest a judge, then that means they could arrest a legislator, they could arrest a governor, they could arrest everybody, all 3 branches of government, when it comes to state, anybody in state government. So can the Trump administration, I cannot stand the way that they're doing these arrests either. The guy, they had administrative warrant. Administrative warrant, is that a real warrant? Some bureaucrat just wrote up a fucking warrant? You didn't even have to go to a magistrate or a judge, just some bureaucrat at a fucking desk in some sort of agency. So the EPA, some clerk from the EPA could just be like, okay, I have a warrant for your arrest. Can anybody just issue warrants? I mean, we're just passing warrants out left and right here. So they did get an indictment, and I can't stand that indictment. You can indict a ham sandwich, that stupid thing. But there is some problems with the grand jury indictment. The grand jury indictment is just the prosecution showing the evidence, and then they were able to get 12 of the 23 grand jurors to say that there's probable cause that a crime may have occurred. That's without the defense, without the defendant, without them providing any evidence. The grand jury is really the prosecution's game. The prosecutor goes behind closed doors, talks to 23 citizens. Who knows where they got these citizens from? So the grand jury is both a shield and a sword. So it's used to protect people from frivolous and superfluous lawsuits, but it also could be a runaway sort of inquisitional show as well. So she's got an indictment. So that's the probable cause. There's been a probable cause hearing. They're talking about an evidentiary hearing, which is another probable cause hearing. So we're going to have two probable cause hearings. I almost think that in some respects, if the evidentiary hearing or the preliminary hearing are done properly and done right, it might be better than the grand jury hearing. But that's only presuming that any of these, the judge or the clerks or the prosecutors or the defendant, if anybody gives a shit about the truth or justice. Ultimately, the preamble says that the whole point of the U.S. government is to establish justice. And I think you can get some claims from the preamble. The preamble has been overlooked, but it's got some sweeping language in it, and it would be beautiful to think that Americans, if all 340 million Americans woke up tomorrow and said, all right, let's try to perfect our union. Let's work on establishing justice. Let's ensure domestic tranquility, promote the general welfare. Let's provide for the common defense, and let's protect our freedoms. Let's protect the blessings of liberty for ourselves and posterity. Those are the 6 end objects. So the 6 end objects are the point of the Constitution. Another thing I want to comment on were these case laws that they had pointed to right here. So they said, since at least the early 17th century in England, this is why I hate common law. Fucking shit do I hate common law. So, I didn't want to talk about common law. I'll mention something here about it in a second. So they said Floyd v. Barker, and this was from the Star Chamber, 1607. The Star Chamber is known to be a very oppressive institution. The Star Chamber? The Star Chamber. It's like it's like Nazi Germany. It's like basically it's been derided as being very oppressive, very unfair. Whatever the Star Chamber says, it goes. Okay, so we're already talking about some sort of fucking common law here. Oh, well, according to the 1600s in England, who gives a shit? Didn't we have a revolution? Didn't we have a revolution in 1776? Why do we care about what was going on in England in the 1600s? Maybe that's just to point out that it's got a long continuum, long tradition, historical and legal tradition or something. I don't know. But it points to common law also. But let's, here they have C. Bradley v. Fisher. This is a very important case. And then Pearson v. Ray. This is also an important case. So Bradley v. Fisher, it isn't a terrible case, but it is pretty bad. And Pearson v. Ray, this is a Dred Scott decision. If I am a lawyer and the opposing counsel says, well, according to Pearson v. Ray, well, my client gets to shit on a brick on top of the library. Pearson v. Ray, if you know anything about Pearson v. Ray, if you don't know anything about Pearson v. Ray, well, I'm about to tell you. So Pearson v. Ray is it's a Dred Scott decision, a Plessy versus Ferguson decision. It's a DeShaney, Winnebago v. DeShaney decision. It's a terrible decision. It embarrasses the court. The court nobody should ever point to Pearson v. Ray as, justifying any goddamn thing. Pearson v. Ray has to do with some black ministers who was in the South, I want to say Mississippi or Alabama. It's always one of those two states, Alabama or fucking Mississippi. I want to say it's Mrs. Tougaloo, right? Tougaloo, is that? Alabama or Mississippi. That sounds like, man, Alabama and Mississippi need to distinguish themselves a little better because they're the twin fucking states of white supremacy. Anyways, just to give you the overall general, specifics might be not perfect here, but Pearson v. Ray is a segregation case. You had 13 black ministers who was at a bus stop. They're at a bus stop waiting to catch a bus to go to their next destination. And while they were at the bus station, they went to go get a cup of coffee. They went to the donut shop. I don't know if it was a donut shop in the bus station or right next door to the bus station. And that's it. That's it. 13 black ministers went to the bus station and they went to go get a cup of coffee and they got arrested because this was the days of segregation. Segregation was the order of the day, and they were arrested for breach of the peace, and the fucking goddamn court systems fucked this case up so goddamn much it wasn't even funny. They did point to common law. Pearson v. Ray, my God. The lawyer in that outfit, she's going to go to the Supreme Court and she's going to be like, well, according to the common law, yeah, we think it's about the common law. She don't know what the fucking common law is. Nobody knows what the fucking common law is. There is no universal definition of common law. So, the common law. So, okay, then ultimately what Pearson v. Ray is going to say, they're going to say a couple things. I don't know if it's like Monroe v. Pape. So the cops are going to get immunity. They're going to get some kind of qualified immunity. But it did come up, Monroe v. Pape, I might be confusing two of them. So that I gave you the basic gist of Pearson v. Ray, the facts of the story. 13 black ministers go to a bus stop in Tougaloo. I want to say Mississippi, but why do I think Tougaloo could be Alabama? Those two damn states, man. Fucking shit. But those are the facts of the case. 13 ministers go to a bus stop and they go get a cup of coffee. And then the cops arrest all of them for breach of the peace. You know how big of a deal an arrest is? And then when the arrest happens and then it gets dismissed and then they file, I want to say, some sort of civil rights claim. And then you have a bunch of legal jargon after that. Sometimes the facts of the case are interesting and they're compelling, but the facts of the case matter to me because in the interest of establishing justice, you want to convict the guilty and protect the innocent, right? That's establishing justice. Those who commit the crimes should not get away with it. Those who did not commit any crimes should. So the cops fucking kidnapped 13, they kidnapped 13 black ministers. This is a terrible fucking decision. They're going to say that the cops get immunity because, well, they had a good faith standard. They operated in good faith. Did they? How do you fucking know? How do you know if they operated in good faith? They were enforcing segregation and then, breach of the peace. That's like disorderly conduct. That's like, jaywalking. It's like some tiny little petty thing that people, could just abuse, well, I might throw resisting arrest on them too. Well, I went and grabbed him and I grabbed his arm really hard and then he slightly pulled away. That's resisting. Versus somebody that's, just attacking somebody, like swerving. Everybody swerves, and so in some respects, can everybody be arrested for swerving? Now, if somebody is literally fucking swerving left and right and left, okay, breach of the peace. The only breach of the peace that these black ministers did was insult the segregation, of Mississippi or Alabama. The only breach of the peace were the cops arresting these ministers. The only breach of the peace was putting these black ministers through all this bullshit. They were the ones breaching the peace. And so the cops are going to get immunity, but then there's also the thing that says that they question the cops. So the cops got qualified immunity. And they were saying that, well, judges have absolute immunity. And why do judges have absolute immunity? If you see here, it says it's citing Bradley. See Pearson v. Ray, citing Bradley. So Pearson v. Ray citing Bradley. Now, Bradley v. Fisher. Okay, I'll tell you what I know about Bradley v. Fisher. This is Abraham Lincoln. This has to do with an Abraham Lincoln case, John Surratt Jr. You had Abraham Lincoln was the president of America, right? He gets assassinated. And then all the assassins and the co-conspirators are going to get hung. You're going to have like 4 people are hung, including Mary Surratt. Now, Mary Surratt had a son named John Surratt. John Surratt fucking took the fuck off. He's first going to go to Canada. And then I want to say he goes to London, then Italy, then Rome, and then Egypt. He's going to get arrested when he's in Egypt, which is kind of incredible, to be honest with you. He's going to get sent back to America. And then there is ex parte Milligan. Civilians cannot be tried in a military court. So the Civil War is over, so now he goes to a civil court. He's going to win his case. He's going to win his case, and this is Bradley v. Fisher is an argument that happened when they were trying John Surratt Jr. So John Surratt Jr. was a possible co-conspirator for Abraham Lincoln's assassination. Okay? Now he's going to get away with it, and then they're not going to... The statute of limitations for murder, too, was 2 fucking years. So as long as you could, hide for 2 years, then you could just reemerge and be like, statute of limitations, which that's insane to me, too. Murder, it wasn't just a murder of like a civilian, it was the fucking assassination of the greatest, man that ever lived. One of the greatest, the great liberator, right? Old Honest Abe. Okay, so Bradley v. Fisher has to do with some of, what I just said about John Surratt and the co-conspirators. There's a famous picture where they hung, the co-conspirators, including Mary Surratt, who was the mother of John Surratt Jr. Now, during the proceedings, you had Bradley v. Fisher, and I forget which one was the judge and which one was the lawyer, but I think Bradley was the judge, and then Fisher was the lawyer. And what happened is they had just had an argument, okay? They had an argument, and eventually, the judge had been admonishing Fisher. Fisher is the one that's defending John Surratt Jr. And Fisher is going to be victorious. But towards the end of the proceedings, Fisher is going to just lose his shit. Fisher's just going to lose his shit, and he just starts insulting the judge. It's like, you've been the worst damn judge on the planet, you pompous ass... you pompous ass turkey. You damn turkey. And then Bradley's like, who you trying to jive? Fisher? And Fisher's like, I'm jiving you, judge. So, that's what Bradley v. Fisher's about. It was just a fucking argument between a judge and a lawyer. The lawyer eventually explodes. And I could see the judge sort of, putting his thumb on the scale, wanting the damn co-conspirator of Lincoln to get convicted. And so Fisher's got like this impossible fucking job of defending his client. And if ultimately he was successful, but he had an explosion and he's kind of insulting the judge. And so the judge bans Fisher from ever practicing law in his court. It was only in that one little courtroom in that one little district or whatever. So it's kind of crazy that a lawyer would take this. I'm going to take this to the Supreme Court. It's like, really? You're going to take this to the Supreme Court? And so, what the Bradley v. Fisher decision is going to come down to is that judges in their judicial capacity have absolute immunity, something like that, in their judicial capacity. And all these terms aren't even defined. What is a judge? What's a judicial capacity? What the fuck are you all even talking about? And so, is it okay for a judge to ban a lawyer and to get him thrown out of the court for life because the lawyer had disrespected him with words? And the Supreme Court said yes. Yes, it's okay. It's okay for the judge to throw the lawyer out because he has absolute immunity. Now, there's a dissent to Bradley v. Fisher, which I think is actually more compelling because it goes to natural law. Natural law is moral law, so therefore natural law is eternal law. So what does the great spirit of ultimate goodness say about any of this? Why would a judge have absolute immunity? The dissent, one of the dissents of Bradley v. Fisher says I don't think a judge who is corrupt or malicious, a judge who is corrupt or malicious should get absolute immunity. And that's fucking right. That's right. That's true. When it comes to absolute immunity, who amongst us is absolutely immune? Me as a citizen, I'm cobbling together all the rights that I get from my state constitution combined with America's constitution. And it's like, we got a right to do this and do that and these little freedoms. But the right to everything is, that goes back to the law of the jungle. The whole point of having civil liberties is that we are leaving the law of the jungle and we are getting back to the law of, civil society. Absolute immunity is the right to everything. Absolute immunity goes against everything that I understand to be true about America. Resistance to tyranny is obedience to God. That's the rallying cry for the American revolutionaries. Resistance to tyranny is obedience to God. We don't want a fucking king because he's absolutely immune for everything that he does. He can steer this ship straight into a damn, steer the Titanic straight into a, what am I thinking of? A big old ice block. An iceberg. He could steer the ship into an iceberg. So resistance to tyranny is obedience to God. So to resist a person that believes they have absolute immunity, absolute power corrupts absolutely. And injustice anywhere is a threat to justice everywhere. So ultimately, I don't know, the deal with Bradley v. Fisher. You'd kind of have to sort through the details because I could see how it could break down. But a lawyer got into an argument with the judge. Who gives a shit? But then the judge is going to ban the lawyer for life, and now the lawyer is suing and say, "Nuh-uh, I get to come back here and I get to practice my law. But you just insulted me, and I don't know where we can go from here." So that's just too hard to determine in some respects. Because unless somebody threw a punch or somebody, pulled out a knife or somebody actually attacked somebody, it's hard to determine who was right and who was wrong. Somebody could be clearly just, absolutely rude and fucking respectful. Chaplinsky says that there's such thing as fighting words. And so if, Fisher is like, "And Bradley, your mom's a fucking bitch, whore bitch. And you ain't shit, you're a bitch, whore bitch too, just like your bitch, whore bitch mom." Some people might think that's fighting words. Threats, that's another limit to speech. Well, Bradley, just make sure I don't catch you outside. So, and the judge has, most of the power during the proceedings. The judge can, get a lawyer in trouble. Lawyers are like bound to obey the judge, but they also have to, fight for their client. So a corrupt and malicious judge would be hard to overcome if you're a lawyer. You'd have to insult them a little bit. You'd have to risk a contempt charge. And then a contempt charge is, a whole nother judge would have to rule on that. But if you ever watched any lawyer shows, and even the good lawyers, you always got to go to, go to jail once or twice. If you're a good lawyer fighting for your client, you're going to butt heads. There was that one lawyer and judge where the judge just had it with the lawyer, and he goes, "Let's take this out in the back." And then they go back there and they're just yelling at each other and screaming at each other. And I don't know if it turned into a physical sort of violent thing. But, I don't see how you could really rule on that just knowing the general, sweeping. So I'm just kind of giving you the generic thing. But the thing I remember about Bradley v. Fisher was that dissent. That dissent, to me, was the ruling thing because Bradley v. Fisher was stupid. You're going to have another absolute immunity case for judges where they had fired somebody because they were a woman. And then there was another case where they said something like, the judge, in their judicial capacity, fine, you're a judge and you're saying, do this and do that, and you're in the courtroom with the robe on, but by firing an administrator, a bureaucrat, because she's a woman, well, that was an administrative job. You're not allowed to do an administrative job. And then there's another Supreme Court case that had said that the judge, or no, it was a prosecutor. The prosecutor gave advice. It was Kalina v. Fletcher. The prosecutor gave advice to the cops, and the prosecutor also elicited false testimony from a witness. Well, according to the common law, which, do I want to get into the common law? How long has this been? If it's under 30. Oh, okay. We'll have to talk about the common law later on. But in Kalina v. Fletcher, the prosecutor was absolutely immune for eliciting false statements from the witness. Now that's going to be changed, and there's other court cases that contradict that. But according to the common law, if a prosecutor was able to get a witness on the stand and then get them to say lies, that was covered. Somehow that was covered. But what wasn't covered in Kalina v. Fletcher, was it 1997, was the prosecutor giving advice to the police. That wasn't covered. A prosecutor is supposed to prosecute, not be an investigator. So the function of a prosecutor is to prosecute, but since she gave advice to the cops, she wasn't covered because she was acting as an investigator and not as a prosecutor. Oh my fucking God. So she was acting outside the purview of a judicial officer. So we'll have to define what does it mean to be a judicial officer. This case is fascinating because I could see that, it is obstruction of justice. You're trying to arrest an immigrant who's here illegally. And the judges, I could see all people's perspective. But the judge, let's say she opened the side door and told the immigrant to go out the back door, and then, goes out a sort of private, hallway, but then it goes out into a public hallway because they said they followed him to the elevator. So he was able to just walk around, to think that that's... She also was charged with 2 felonies. Fucking felonies. So I both hate and love this case because judges are fucking bullshit, man. Judges are fucking bullshit. They are such fucking assholes. They act like they're untouchable and they're above everybody, and a lot of times they are in some respects because of absolute immunity, and that's how convenient. The Supreme Court, a bunch of judges, gave themselves absolute immunity and all their other fellow judges. That's fucking convenient as fuck. But I hate it that it's this stupid thing that a judge opened the door and told one of the people in the courtroom to go out this way. And then the whole way that the ICE people come in, they got this administrative warrant, then it's go talk to the chief judge, and while they're talking to the chief judge, she ushers them through the fucking side door, the jury door, whatever. Is that an illegal? Is that a felony? Is that, 2 felonies? It's on Good Friday, too. Jesus says that you care about, tithing cumin and dill. Cumin and dill and mint. But you forget about the important issues of faith and mercy and justice. This is a petty fucking nothing. This is a petty nothing. Did you not get your man anyways? You were able to arrest the guy, right? And you had an administrative warrant. They're doing all these fucking illegal shit. So, in a way, doesn't... The Underground Railroad. You had a case, the Kentucky v. Deming? Kentucky v. Deming? What is it? The... Kentucky v. Denison. So, Kentucky v. Denison, 1861, this is a case where a black man in Kentucky had told another black man the way to run to the north to get freedom. And then he was charged with a felony. And he goes to another state, and then the state's like, I'm not giving him up. I'm not giving him to you, you fucking fuck, because he goes to Ohio, a free state, and the free state wasn't going to give his buddy to a bunch of slave fucking, owning racist piles of shit. And what does that have to do with anything? Sometimes when you have oppression and bullshit and legality, you gotta, push back. So they're fucking kidnapping people, and they're just putting them on planes and shipping them to God knows where without due process. And so to push back against that would be genius. So who's the tyrant in this? It seems like ICE is the tyrant. Judges can be bullshit, and so while I don't hate the idea of a judge being arrested, and the way that they're saying here was that law enforcement is the local police. So they're kind of saying that it shouldn't have been the feds who arrested her, but the local police. So this dismissal is saying that the people that should actually do the arresting of judges, of state judges, should be the state and local and county police. Which, in a way, maybe that would have solved Mickey Stein's problem. Instead of shooting the guy, he could have just arrested him. The judge in Letcher County. So I could see, we'll just say, the Trump administration's perspective that, hey, I was trying to catch this illegal, and you opened the door and you made him run out the side, and we didn't see which way he was going, and then we might not have got him. There was a foot chase and then a tackle. Did anybody get hurt? Did where's the injury? Where's the injury? Where's the wrong? You were obstructing. Petty dumb shit. Petty fucking dumb shit. And then they're such tyrants that they think that if somebody, gives somebody a degree of sanctuary, hey, maybe if you just hide under the covers, hey, did you just tell him to hide under the covers? Well, you're a felon times 2. Because I told him to hide under the covers. You found him. He was hiding under the covers, and there he was. How the fuck? Because I told him to hide under the covers? Yep. Well, what if I would have said that, he has a right to due process? They were getting mad at Ilhan Omar for telling legal, lawful immigrants their rights as Americans. Yeah, where are my papers? Where are your papers? Who are you? What's your badge number? I don't have to tell you that. Well, then that means you're just kidnapping people. How are we going to stop these ICE motherfuckers, or people pretending to be ICE motherfuckers, kidnapping women? They're just basically, clad up fucking men dressed up in hoods, jumping out of vans, grabbing people and throwing them into a van. And that's justice. That's the good guys. Those are not the good guys. The good guys are the ones that are fully uniformed, fully, with ICE, a vehicle that has decals on it. They are the police. They are the federal officers. They have the uniform, they have the badge number, they have the works, right? And then they have the vehicle. But just being a bunch of hooded up motherfuckers throwing people into unmarked vans, you're given permission to allow anybody to do that. How many people, pretend to be police officers? Criminals could just do a cop knock and be like, police, open up. And then if you open up, well, then you just opened up, the door to the vampires, right? You just allowed the criminal fucks to come in. Why? Because they said that they were the police. So my inclination is that Hannah Dugan is good and right and proper and decent, and she'll ultimately be victorious in her lawsuit. And that's good, because I see the tyrants being these ICE motherfuckers that are just jumping people at the courthouse. Like, they could have waited outside the courthouse. They have to arrest people inside the courthouse. Isn't that, a breach of the peace? Isn't that disorderly conduct? To just go into somebody's courtroom when they have all these proceedings and to be making these arrests? When there's only so many entrances in and out of a courthouse. I mean, is there some courthouses with like an underground tunnel? They could have just stayed outside, identified the person when they saw the person, go in or out. But instead, it's like they would rather just have a sure shot, right? They want the guy's name to be called, and then they're like, oh, that's him. He looks like the description. They said his name. They said it out loud. We're going to go ahead and arrest him right here, right now. It makes me think of Marianne Bachmeyer, too. She got vigilante justice in a courtroom. What, this man just killed my daughter and you want to have, like, fucking evidence and witness statements and shit? She just carried a pistol into the courtroom and shot the bastard. And I think she's right. She was right in that case. And she said, I did it for you, Princess Anna. So I could see, both perspectives. But, yeah, that's the indictment.